Hold on, let me get my notice. Do you want to start, Joe, and just get through the minutes and the
Yeah,
resolution?
we can do
Yeah.
that. Eileen, you want to read the
I will read.
prelim?
I will read the charge. Hold on. Okay. In accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, be advised that notice of this meeting was made by posting on the bulletin board in Town Hall and mailing to officially designated newspapers a list of the meeting dates annually, indicating that this meeting would take place on Monday, December 21st, 2020 at 7 p.m. Due to the mandatory quarantines imposed by Governor Murphy, Millburn Town Hall is closed to the public for the purpose of board meetings. As such, this meeting is being held in a Zoom webinar format. Supplemental notice of this transformation of the meeting to a virtual format was posted on the bulletin board in Town Hall, taped to the front door of Town Hall, posted on the township website, and forwarded to the Item and Star Ledger, the officially designated newspapers of Millburn Township. Mary McNatt?
Here.
Craig Klettner?
Here.
Jody Sharma?
Here.
Steve Toger?
Here.
Wolfgang Tutoris?
Here.
This was not here. Chairman Joseph Steinberg.
Here.
Did I call you Joy? Joy Siegel. I
No,
skipped.
Joy, see you.
Sorry about that. All right. Okay. All right. It's all yours, Joe.
All right, what's the first matter on the agenda? Minutes?
We have lots of minutes. We have minutes of September 21st, October 5th.
I think Jessica Glad is about to come on.
Okay.
Okay, Jessica, there you are. You're muted. Now you're
Yeah,
unmuted.
I'm good. Thank you.
All right, which minutes are first?
September 21st.
Who was at that meeting?
Mary, Craig, Jody, Joy, Wolfgang, Kevin, Jessica, Joe Steinberg. Actually, yeah.
One of you like to make a motion to adopt those minutes?
I'm going to move approval of the minutes of September 21, 2020.
Is there a second?
Second.
All in favor?
Aye.
Next set.
Minutes are October 5th. We had a regular meeting, we had a regular minutes, and we also had closed session minutes, which I forwarded, and I guess Gail.
Let's do the open set first.
Yeah.
Who was there?
Mary, Craig, Jody, Joy, Steve, Wolfgang, Kevin, Jessica, everybody, I guess, yeah.
Anyone want to make a motion with respect to these minutes?
You could do both sets. You could do the executive and regular session with one motion.
That can, the closed session can be released at this point, right?
Yes.
Okay,
Same people were at the closed session?
yes.
Okay. Is there a motion?
Motion to approve minutes of 10/5/20.
Second?
Second.
All in favor?
Aye.
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 Next agenda, next minutes were from November 2nd.
Who was there?
Joy was the only one not there.
All right, Joy, you can't vote on that. Is there a motion to adopt these minutes?
Move approval minutes, November 2nd meeting.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Joy's an
Next.
abstention.
Next set?
Next set is November 16th. And everybody was there.
Is there a motion on this set?
Move approval minutes of November 16th.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Aye. Opposed?
And last but not least, December 7th.
We're getting close. Who was there?
Everybody.
Everybody?
Mhm.
Is there a motion?
Motion to approve. Defer.
Second?
Second.
Second.
All in favor?
Aye.
Aye.
Oh,
Opposed?
so excited to get them done.
Are we done with the minutes? Yes.
We are.
We don't have a set for tonight yet.
Not yet. I could do them as we're speaking though, and we could approve them right on the spot. I am so glad to get them done finally.
Yeah.
Okay, so now we have memorializations. We have calendar 3763-20, Alex Rubenstein, 40 Main Street,
40 Main Street.
correct.
All right, who's eligible here?
All full members with the exception of Joy.
Is there a motion to adopt the memorializing resolution for this case?
Motion to adopt 376320.
Mary?
I'll second.
Got to keep things moving, Mary.
Mary McNatt,
Yes.
Craig Putner,
Yes.
Jody Sharma,
Yes.
Steve Toger,
Yes.
Jessica Glatt,
Yes.
Joseph Steinberg.
Yes.
The next one is calendar 3769-20, Mohebi. All full members, with the exception of Joe Steinberg, are eligible to vote.
And what was the address of this property?
Mohebi.
30 Harvey Drive.
Yeah.
All right. Is there someone who's eligible who would like to make a motion with respect to this resolution?
I'll make a motion. Approval, calendar 3769-20.
Joy, did I see you seconding?
That's okay, I second it.
Okay. Mary McNatt,
Yes.
Craig Putner,
Yes.
Jody Sharma,
Yes.
Joy Siegel,
Yes.
Steve Toger,
Yes.
Jessica Glatt.
Yes.
And the final resolution is for Donald and Kathleen Fiore, 124 Cypress.
This is the Cypress. Who's
yes.
eligible here?
All full members.
Is there a motion to adopt this memorializing resolution?
So moved.
I'll second.
Second?
Second.
Mary McNatt,
Yes.
Craig Putner,
Yes.
Jody Sharma,
Yes.
Joy Siegel,
Yes.
Steve Toger,
Yes.
Jessica Glatt,
Yes.
Joseph Steinberg.
Yes.
All righty.
Gail, you want to talk about the letter?
If you'd like me to.
Go ahead.
Ms. Davitt received correspondence from Matthew Kopaleckia, the attorney for Bezod and Jennifer Soltani at 377 Wyoming Avenue. That was the fourth case that the board heard on December 7th. That resulted in a decision to deny the approval requested for 3 variances. And the letter is a request in support of a request for reconsideration. He's characterized it as a motion for reconsideration, but obviously it is a letter request. The board's not a court, but he's asking that the board reconsider its decision. The letter takes the position that the request is proper because the board continues to retain jurisdiction as it has not issued a final memorializing resolution. And citing cases that the board may grant a rehearing, and it's within the sound discretion of the board. The case he's citing to is a case that does not appear to be a zoning board case, because the quotation is that reconsideration is a matter within the sound discretion of the court to be exercised in the interest of justice. And his position is that the board should be guided by the standards in court rule for reconsideration. They sought a C1 variance, placement of the air conditioning and the pool equipment in the front yard and the installation of the in-ground pool. They want to clarify the record for the board to reconsider that. And the letter goes on to state there's a set of approved building plans on file with the Millburn Building Department that were dated in July 2019, which depicted the location of the air conditioning condensers in the front yard. The applicants contend that they relied upon that approved set of building plans in connection with the configuration of the proposed placement of the air conditioning condensers. Although the ordinance prohibits that placement, they reasonably relied upon those approved building plans for the proposed placement of the air conditioning pad and the pool equipment. They allege the significance of that fact is to dispense with any argument that they sought to circumvent the zoning requirements or manufacture a hardship regarding the property. To the contrary, they constructed the home in conformance with the approved building plans on file. They go on to argue that reconsideration is proper because the board seemingly further overlooked that the shape of the lot and the shallow depth from Elm Street is what creates the hardship. And as noted in the testimony, the letter alleges that variance relief would be needed for the placement of any accessory structures due to the required 80-foot front yard setback mandated by the ordinance, and that the existing lawful structure did not cause the hardship. It is the land that causes the hardship. It alleges that the matter is like Lang versus Zoning Board of Adjustment in 1999 case, where the court made clear that the hardship refers solely to particular physical conditions of the property. Placement of the pool remains properly shielded from the streetscape by the structure, and the proposed relief in connection with the pool does not impair the zone plan and is without substantial detriment to the public. It appears the board did not consider these facts and rather focused on the placement of the air conditioning condensers. In fact, there was seemingly limited questioning by the board regarding the pool, and the applicant contends that reconsideration is justified to determine the reasoning of the board members who voted against the pool element of the application. And to this end, and as an alternative to full reconsideration, the applicant remains agreeable to a partial reconsideration as to the pool element of the application. And in such a case, they would be prepared to address the concerns of the board during any rehearing regarding the placement of accessory structures. Presumably that means the pool equipment and air conditioning condensers. And they respectfully request the board's attention and discretion towards reconsideration. And if the board is inclined to grant a rehearing, it requests that the board fix a date, and they're prepared to give notice to all interested parties. So that is the request. I spoke earlier with Chairman Steinberg. I think I recall perhaps in my 18 years as a board attorney, maybe we got 1 or 2 requests for reconsideration. I really don't ever recall the board ever granting a request for reconsideration. So I just point that out. And if you recall, this was not a resolution authorizing me to draft a resolution. This was actually a denial.
Do you have a legal opinion as to whether or not this board has the authority to grant a reconsideration?
I think that's debatable. I don't believe the board has any bylaws. I mean, typically, if the board had bylaws, it could address something like a reconsideration issue. The board is not bound by the court rules, as you all know. It is not a court of law, while it is quasi-judicial. So, in my opinion, I'm not sure that a request for reconsideration is appropriate in a matter before the board. And I really don't recall the board ever granting one in the past, but
Thank you. Anybody on the board have any comments with regard to this request for reconsideration?
I have a question. Gail, are they saying that the pool equipment was on the original plans that were submitted to the building department?
no, it claims that the pad for the air conditioning condenser was on the pad that was submitted to the building department. And they're relying on that to suggest that they relied on that set of building plans to justify their placement of the air conditioning and the pool equipment in that location. But I should point out that even if the building department approved the set of plans, that if those plans show the air conditioning condensers in a location contrary to the zoning ordinance, then the building department was without authority to approve that. That would be ultra vires. So they had no authority to authorize the placement of air conditioning pad in the front yard because it would be contrary to ordinance. And they don't have the ability to grant that approval. That can only be done by the Board of Adjustment or by the Planning Board if it were appropriate application before the Planning Board.
I asked them specifically if they could put the air conditioning units on the side of the house and comply, and the answer was yes. So they don't have to go in the front yard. And as far as I'm concerned, if they want to reapply, that's up to them. They can reapply with a substantially changed application, couldn't they?
That is correct. They would have to change the application in a way for the board to determine that it was substantially different to avoid the doctrine of res judicata applying. And the board has had cases like that in the past where people have come back with a different application. And you have made that determination on that res judicata has not been applicable because of substantial changes in the application.
Gail, do you feel that this board, if it were to deny the request, needs to do so with a formal motion?
I think it could be done by a motion and a second and a voice vote. I don't think you need a roll call vote.
Is there anyone on the board who was
Sorry,
prepared to?
can I just ask a question really
Yes.
fast before we move to that? Gail, or do you have the impression that if we don't grant the motion, or their request to reconsider the application, that they're going to appeal the board's decision?
I have no idea, but that is the appropriate remedy. The board has denied their application. We have yet to memorialize it, which the board will do at the first meeting in January. I just did not get it prepared in time for this meeting, although I intend to get it done as quickly as possible. And then they have a 45-day window to appeal. And that is their appropriate remedy.
Okay. And then the case that we had that time, I think it was on Highland. Was that a motion to reconsider, or do you remember the one that I'm talking about?
No, I really don't, because Joe and I talked about this earlier, and I said to him, I know that perhaps we've had one or two requests. I just didn't recall us ever granting a motion for reconsideration. We have had cases where they have come back, for an amended application to make modifications. They've sought amended relief, but
Not a full reconsideration.
Well, let me ask this.
I don't recall.
Is there anyone on the board who believes that we should grant reconsideration in this case? I see no one is jumping forward to make that recommendation. So is there a motion to deny the request for reconsideration.
So moved.
Is there a second?
Second.
All in favor of the motion, which is to deny reconsideration, please raise your hand so that I can see them and Eileen can see them. I see every hand of a regular board member raised. Anyone opposed to the motion? It's unanimous, Eileen. The motion, the request for reconsideration is denied. Is there any other matter on the agenda? I'm sorry that I don't have a copy of the agenda in front of me.
It's
I
just the
did
New
not-
Jersey
I did
Energy
not-
case.
No, it's just NJ Energy.
Okay, so we'll take
Okay,
US Energy.
So, okay, I need Matt Fasada. And I'll let him tell me who else.
Matthew, you're on camera.
All right.
Matthew, who else am I bringing over?
Just myself.
Just you, okay. Like it.
Well, I think Matt was getting ready to cross-examine the objector's witness.
Yes, Mr. Michael Pesolano, planning expert.
Right.
Okay.
Signing off then.
So I'm trying to remember whose witness was Mr. Pesolano.
He was
He was the area, the Reeve Circle, I believe, correct?
Okay.
For the residents, I'm pretty sure he was there.
Yes, that is correct. This is Michael Pesolano speaking. Hello.
So
everyone.
who else should be coming over?
I don't think anybody else. I just think,
At the public portion, of course, my clients will be weighing in, but
Okay.
there may also, well, I'll let you know.
Mr. Pesolano, we'll just remind you that you are still under oath.
Agreed?
Thank you.
Thank you.
Mr. Posada, proceed.
Thank you. Mike, good evening. Good to see you as always. It's always a pleasure. You stated at the last hearing that you disagree with Mr. McDonough that a gas station existed at the site, correct?
No, I did not disagree with that.
Okay. What was your testimony? 'Cause I believe on page 72, line 18 through 20 is when you say disagree with Mr. McDonough that a gas station existed at the site. So can you please provide clarity?
I don't have the benefit of that transcript in front of me, so I won't be able to say I see the same words as you. There was a gas station obviously there at one time, if that will address the question you're hunting for.
You had stated before on the record that you had had the opportunity to review the application documents, including those that were on the township's website, correct?
That's correct.
Okay. Have you reviewed the resolution of approval for calendar number 1945 dated June 17, 1996?
I did not read that resolution.
Okay, then are you aware of that resolution conceding that a gas and service station is a pre-existing non-conforming use?
Okay, that seems fair to assume, so I don't have any argument with that.
And did you discover that in any of your due diligence when reviewing the subject site?
Any of what, Matt?
That this was a pre-existing non-conforming use that was confirmed by this board in 1996.
By virtue of mention of that resolution, the pre-existing non-conforming status came into the picture during this hearing. However, I was already of the belief that it was a pre-existing non-conforming situation.
Okay, and then through doing your due diligence for the subject parcel, are you aware that an auto service station has existed as a use on this site since around the 1930s?
It is my understanding that that use, along with a florist shop at one time, were uses that occupied this property.
Are you aware that the resolution of approval for 1996 also included the approval of a canopy, and a canopy which would also include signage?
I have no reason to doubt that content in the resolution.
Since 1996, through doing your due diligence, have there ever been any moments where you can specifically point to where there was a break in the chain of the proposed intended use of a gasoline service station?
I cannot.
Okay. Now regarding the traffic, is it correct that your previous testimony included a statement that vehicle operations to and from the site could potentially put people in harm's way?
That is my testimony.
What data were you relying on for that testimony?
I was relying on observations about the approaches to the site.
So your statement was based on speculation, correct?
Not at all. It was based on observation.
Are you a licensed traffic engineer?
I am not and did not represent myself as that.
Okay. Next item I want to just talk about real quick is you had mentioned in your testimony, if I am correct, regarding the concerns for flooding, correct?
I recall mentioning testimony about the site being flood prone.
Okay. You had highlighted landscaping as being an issue too, correct?
What's the context? Please refresh me, Mr. Posada.
I believe that you had discussed about the fact that more landscaping could be improved on the subject site in order to alleviate the stormwater concerns.
Gee, I don't recall that part of my testimony. I may have said it, but I truly don't recall saying that.
Well, would you concur that additional landscaping to a substantially impervious coverage area would help alleviate stormwater concerns?
It's preferable to paving, yes.
Is it your understanding from reviewing the subject application that what exists today compared to what's being proposed, that landscaping would be increased for the site and therefore help alleviating stormwater concerns?
That's a fair conclusion.
Okay. And then just to go back, are you aware that the subject application would have a reduction in impervious coverage for just over 15% of what's currently there on the site today?
I'm sorry, your question didn't quite gel with me. Could you repeat that? I'm not sure, the way you framed it doesn't sound right. So let's take it from the top, please.
Let's take it from the top. Then would you also agree that the proposed application, which reduces the impervious coverage by over 15% and
Okay,
landscaping, would help alleviate those
okay, yes.
concerns? So then, is it your testimony that these proposed improvements would help alleviate the stormwater runoff of the subject site, which was also testimony provided, or I should say testimony, comments from the public as a concern for the subject site?
It would help improve, yes.
Okay, and would you agree that the proposed usage of a convenience store with a gas station is more consistent with those modern trends of what's being demanded by the public at large than an auto service station and a gas service station?
There appears to be a trend towards gas stations and convenience stores
Okay.
versus gas stations opening with service space.
Then would you agree with the statement then that the auto service station with the gasoline service station tends to be outdated?
No, I would not.
Okay. I have no further questions for this witness.
Any questions of this witness from the board members?
Well, I'd like to just comment that, because I believe I was part of the issue, the first question asked about if it had always existed as a service station. I think that the applicant's professional had indicated that the site had always existed as a service station and convenience store. The professional had sort of coupled those two together. And I had, in my questioning of the professional, I said, it's always been a service station. It hasn't always been a convenience store. And he said, yes, that's accurate. And I believe that, Michael, that's what your testimony was too as well. At least that's my recollection.
Okay, I think that sounds more realistic. Thank you for that clarification.
Any other questions from board members? Is there anyone in the audience who has any questions of this witness?
I believe that there's an
There are
intention.
hands raised.
Okay,
There are hands raised. Now, just let me be very clear to any members of the public. I'm asking if there are any members of the public who have any questions of this witness, questions only. This is not the time for statements. Is there anyone who has any questions, Eileen? Apparently not. Is that true?
Yeah, there are hands.
I had to unmute myself. Let me start my video.
Muted.
You're muted.
Unmuted myself. There we go. Now can you hear me?
Yes.
Okay, thanks.
Now you understand I'm asking for
Yes, I
questions only.
fully understand. Mr. Pesolano, in the course of strike that, did you speak with residents of Reeve Circle other than, I'm just talking about conversations with people other than those who retained you? I don't want to invade any privileges if any privilege is attached. Did you speak with members of Reeve Circle?
I did speak with residents of Reeve Circle, yes.
And in the course of speaking to them, did any of them happen to mention that, in fact, there was a break in intended use by virtue of the operation of a nursery, a plant nursery on that site for approximately 10 or so years in the 1960s?
The plant nursery use was what I referred to earlier tonight as the retail florist.
Okay.
If the actual use was plant nursery, please forgive me, but I do recall it being mentioned that that was part of the use history of this site.
Okay. So would you agree that based on your investigation as conducted through interviews of Reeve Circle residents, that in fact the station has not been continuously used as a gas station since the 1930s?
Based on that recollection, yes.
Okay, thank you. And did also further based on your conversations with the residents, did any of them ever disclose to you that one Harry Rosenthal was struck by a car backing up in the rather tight parking lot of that gas station in or about 1997?
Yes.
Okay. All right. I don't have any other questions. Thank you.
Mr. Posada, any redirect?
No, thank you.
Any other members of the public have any questions only of this witness?
Yes, another hand is raised.
Let's bring that person in, please. Fiona Phillips,
Hello, can you hear and see me?
we can hear you and see you.
Wonderful,
This is the
thank
time
you.
for questions of this witness only.
I am aware, thank you. Mr. Pesolano, you testified at a
Your
prior,
address, Ms. Phillips?
sorry, Fiona Phillips, 15 Reeve Circle.
Thank you.
So, Mr. Pesolano, you testified at a prior hearing that you thought the confluence of all the potential site users with regards to the property boundaries could be quite intense and could have some, and could essentially be unsafe. Is that correct?
That's correct.
Okay, can you give us a little bit more information about how you came to this conclusion?
Yes, I believe that the applicant's proposed addition of a highly intensive second use on the physically constrained site, plus the potential for cut-through traffic, plus the invitation to pedestrians, including children on foot and bicycle, plus the widely known characteristic of convenience store combos serving people in a hurry, plus the multiple avenues of approach by drivers in a hurry were basically the points driving my conclusion.
So based on your response to that prior question, is it your professional opinion that adding a secondary primary use is in violation of the Millburn zoning ordinance and could potentially and realistically create a safety hazard, a frequent safety?
Yes.
Okay. The applicant testified through its witness that the site will function safely and efficiently as proposed in the current plan. Is that correct?
Yes.
Okay. So do you have a different opinion with regards to the safety of the proposed plan?
Yes, I believe the site suffers from too many directions of approach such that maneuvers on site are influenced by a great variety of off-site maneuvers.
Okay. So is your opinion based on a safety expert?
I acknowledge that I'm not a credentialed traffic expert.
Okay.
But I base my opinion on experience and knowledge as a licensed professional planner in the state of New Jersey, whom by virtue of the Code of New Jersey may prepare a site plan, including elements such as circulation and parking, specifically the location of drives, parking layout, pedestrian circulation, and means of ingress and egress. The law also allows professional planners to show the general layout of a conceptual site plan for a multiple building project, showing the development elements, including their relationship to the site and immediate environs. Inherent in the authorization to prepare site plans with such information is the understanding that professional planners, by virtue of their education and experience, have sufficient professional knowledge in these areas.
Okay. So is it your opinion that the proposed convenience store building exhibits a good planning and zoning? Do you think that's a good thing?
I still maintain it as poor planning. So that is correct.
Why do you think it's poor planning? Why don't you think it's good?
Principally, the proposed convenience store building is jammed into the frontmost corner of the property, encroaching on the highly visible front yard of not one, but two frontage streets, where a building is not permitted in the first place. It's poor planning to grant setback variances to accommodate such a building.
Okay. So you heard the applicant's planner testify that the proposed C-store building creates a wall effect and buffers residents' use from across Millburn Avenue from the pump islands. Is that correct?
Yes.
So is there more to that story? Is there more, is there more representation? Is there something else that the board should know about this arrangement?
Yes, the board should know that the alleged buffer here is itself in violation of the setback requirements in the form of a building, and in fact will sit on the front line following the proposed dedication of right-of-way shown right on the plans. It's also characterized by the rear of a building facing the public realm, a highly discordant and unusual arrangement in Millburn Township. There's no evidence on the record that building rears facing front is a common feature in commercial use in Millburn Township. If there's such a value in having buildings with the front yard setback to serve as buffers of other site elements in Millburn Township, there would be evidence of such arrangements, yet none have been demonstrated by the applicant who bears the full burden of proving such matters.
Okay. The applicant testified, testimony has indicated that the gas sale use has existed on the site for many years. Is that correct?
That is correct.
So is it your opinion that the tenure of a particular service serves as a valid criteria to grant the D1 use variance to allow a second non-permitted use?
It does not constitute such criteria.
Is it your conclusion that the proposed retail convenience store has never been on the site, and in fact specifically was excluded from the zone by the governing body following the last master plan re-examination?
Yes,
Okay. Is the municipal governing body the only public body vested with the power to zone in New Jersey?
yes, it is.
Okay. That is all the questions I have for you. Thank you so much.
Thank you, Ms. Phillips.
Thank you. Mr. Posada, any questions of this witness?
Yes, I'd like to redirect. Mr. Pestilano, you had stated before that the use does not constitute such a criteria for a D1 use, correct? The existing site?
I'm sorry, the audio broke up there. Could you repeat the question?
You had stated it before in your answer that it does not constitute such criteria to warrant a D1 use. Is that correct?
I said that the history of the use on the property does not serve as criteria for the grant of a second use to be allowed.
Okay. Are you aware of Municipal Land Use Law, Subsection 68, non-conforming structures and uses?
I am.
And are you aware again of the resolution of approval dated of 1996? So therefore, subsequent to this quote unquote lapse of time, which the applicant has never conceded to, nor has the applicant seen any evidence displaying same, that this very zoning board in 1996 confirmed that the subject use of the auto service station and gasoline service station is an pre-existing non-conforming use.
Yes, I verified that earlier in your cross-examination of me.
And you're also aware.
I did not dispute that. No.
Okay. And you do not dispute that either, that unless there is an abandonment, an individual owner and or property owner is allowed to continue that use, correct?
That is correct.
Thank you. I have no further questions for this witness.
Thank you.
Thank you.
Are there any other members of the audience who have any questions of this witness?
There is someone else with their hand up.
Yes, Marilee Rosen.
Hi, Marilee Reesbeck.
Reesbeck, I'm sorry.
Yeah, 91 Whittingham Terrace, Millburn.
Do you have any questions of this witness?
Yes, I do. There was an announcement just a month ago, Mr. Pestilano, so I don't know if you would be aware of this recent development, but there was an announcement that Essex County will be receiving over $26 million in federal grants from the North Jersey Transportation Planning Authority to make safety improvements at 39 intersections in the county. And these have been identified as some of our most heavily traveled corridors, according to County Executive Joseph DiVincenzo. This intersection at Millburn and Vauxhall is included as one of these 39 intersections. And the project includes extending curbs, installing refuge islands, shortening crossing distances, and installation of leading pedestrian interval signals. So this inclusion of this intersection as one of the county's most heavily trafficked corridors, would you say that this assessment is in conflict with the rather rosy picture painted by the traffic engineer provided by New Jersey Energy?
Well, to be frank, my interest is not to contradict the traffic experts' traffic engineering assessment. As earlier acknowledged, I'm not a traffic engineer. However, my opinion about the site's relationship to that intersection you named remains very spot on, that it is at the confluence of so many avenues of approach and departure that it is a very, very busy location and an inappropriate one to which is an inappropriate one for which an additional high-intensity use should be added.
Thank you. That was the end of my question.
Thank you.
Thank you.
Mr. Posada,
I have no questions. Thank you.
anyone else in the public have any questions of this witness? Questions only. Thank you, Mr. Pesolano.
Thank you, everyone.
There are no other hands raised.
None. Anybody on the board have any more questions for Mr. Pesolano?
All right, now is the time for members of the public to have an opportunity to speak to the application, one way or the other. Please raise your hand and you will, if you wish to speak with respect to this application. Are there hands raised?
Yes.
Okay, I'm going to go in the order they're here. First one is Fiona Phillips.
Hello.
Ms. Phillips, now you have to be sworn in and you have to state your name and your address after the court reporter swears you in.
If you would just raise your right hand, please. Do you swear or affirm the testimony you're about to give in tonight's hearing to be the truth, the whole truth, nothing but the truth?
Yes, I do.
State your name and address for the record, please.
My name is Fiona Phillips. I live at 15 Reef Circle.
Thank you.
You have an opinion with respect to this application?
I do, and I actually just want to share with the board some perspective. So I've lived on Reef Circle for about 5 years, I just want to share some perspective about the potential gas station and convenience store and the impact it will have on the quality of life of our residents in the Circle. You may not know the Circle really well, but it's a traffic-free, no-through road. It's a quaint cul-de-sac with about 12, 15 kids, some of which include grandkids that come to visit their grandparents. The children in the Circle really have a special life. It's amazing to see how they can play carefree outdoors, and it really supports their development and social skills. On any given day, especially in the summer, you can see 6 to 8 kids playing for hours. As I mentioned, it's very carefree. You know, the kids will only stop in someone's house for a quick snack or a drink, but the laughter and the joy that you hear is truly heartwarming. These kids have, you know, really developed some independence. They may be doing picnics. They will be sort of nurturing their horticultural skills as they're digging in the Circle. You know, they play gaga. They've learned how to ride bikes. They host play dates. These are just some of a few of the things that these children are doing. In a world where children are spending more and more time on electronic devices, this Circle is a crucial resource and relief for the development of these children. The American Academy of Pediatrics in a Harvard medical article tells us that outdoor playing helps our children. It promotes social skills, emotional well-being. It helps with their cognitive skills, their executive function. It helps them with prioritizing and problem solving and negotiating and multitasking. It also just helps these kids, as I mentioned before, just develop a sense of independence and build confidence and bravery as they go out and play independently. These kids have learned social skills. They've learned how to work together, how to cooperate, how to negotiate, as I said. And our children really have a strong appreciation for nature, given that they live on this circle. They walk around the circle, and they really appreciate the inhabitants, the birds. Sometimes we see deer on the circle. The circle represents everything that Millburn stands for. It's diverse, it's family oriented, it's friendly, it's safe, and it has a strong, strong community spirit. And I strongly believe that developing this gas station and convenience store will have severe repercussions on those that live in the circle. I believe it will increase traffic. Drivers will not realize that it's not a through road, and it will pose severe danger and to the safety of our children, and ultimately sort of inhibit their free spirit that they currently have. So in conclusion, I just want you guys to take away that the current plan will affect the children that live on the circle. It will impact their independence, it will impact their social skills, their emotional skills, and their cognitive skills, just to mention a few. I know that young children, just really can't accurately judge the speed of a car or the distance of a car. So I just really want you to be aware that this potentially building this and approving this plan could put these children in a vulnerable position. Thank you.
Thank you. Is there anyone else in the audience who has a statement he or she would like to make?
Yes,
with
I'm
respect to
going to
this
bring over
application?
Henry Bloom at this time.
Mr. Bloom.
Yes, good evening, everyone. My name is Henry Bloom. I reside.
Wait, I need to swear you in first.
Oh, sorry about that. Yeah.
Is there a way you can turn on your video or no?
Need your video.
Yes, sorry.
Okay, if you would just raise your right hand, please.
Yes,
Do you swear from the testimony about to give in tonight's hearing to be the truth, the whole truth, nothing but the truth?
I do.
Your name and address for the record.
Henry
Lost him.
Bloom, 4 River Lane in Millburn.
What is your address?
So at 4 River Lane in Millburn. So in addition to being a resident of Millburn, I'm also an officer of Congregation B'nai Israel, the synagogue that's located at 160 Millburn Avenue. Our synagogue is located directly across the street from the property in question. And so I'm here this evening to make a statement on behalf of the synagogue and also in my individual capacity as a concerned resident of Millburn. So we're aware that the applicant has requested a waiver of the environmental impact statement, and we feel strongly that a waiver should not be granted. Instead, we believe an impact statement should be obtained and examined before any approval is granted on the application that's now pending before you. Given the existence of large and old underground fuel storage tanks at the property and the very close proximity to our synagogue property, as well as to the Rahway River, we're very concerned about the potential environmental impact of reopening a fueling station. Our concerns regarding this issue are not mere speculation. We're aware that prior to the 2009 fire at the Exxon station at this location, contamination had occurred. And we don't know if these fuel storage tanks have caused subsequent and further contamination during the many years since that work was performed. But we therefore respectfully urge that any decision by the board should be made based upon a full and objective information regarding the current status of the fuel storage tanks and whether they do or do not pose an environmental threat to the surrounding Millburn community and to the nearby Rahway River. For those reasons, we urge that before any decision is made on the pending application, the applicant should provide an environmental impact statement, including but not limited to a study relating to the underground fuel storage tanks. Thank you for considering our views.
Thank you.
Chairman, I'd just like to point out to Mr. Bloom and to the members of the public that although the applicant requested a waiver from the environmental impact statement, the board did not grant that waiver, and the applicant has in fact provided an environmental impact statement for this property that was dated November 27, 2019, and it is part of the application, and it does address the inventory and the underground tanks that are there right now. And I think it was the last hearing, if not an earlier hearing, the applicant confirmed they do not intend to reuse those tanks. They intend to pull those tanks and install new underground tanks. So in the course of that work, the DEP will be involved.
I would
Thank
just
you.
add to
Thank you.
that the applicant, Mr. Posada, in fact, testified that the decision to replace those tanks was not a result of the study, but was an assumption of what he defined as best practices
Right.
on the part of the applicant.
Mhm. But there is in fact an environmental impact statement that's part of the record. The board did not grant their request for a waiver.
I'm holding it in my hand.
All right.
It
Thank
is
you all. Thank you
dated,
very
as
much.
council stated, it is dated November 27, 2019. Copies of it were provided to every member of the board.
Okay, thank you.
Is there anyone else in the audience who has a statement he or
Yes.
she would like to make?
I'm bringing over Judith Rosenthal at this time. There are about 4 more that have.
Good evening again, Judy Rosenthal.
Right, just, do you swear from the testimony you're about to give in tonight's hearing to be the truth, the whole truth, nothing but the truth?
I do.
State your name and address for the record, please.
Judy Rosenthal, 97 Main. I want to amplify what Fiona Phillips had said earlier. I actually grew up on Reeves Circle, and I was very touched by what Fiona had to say, because I am a product of that culture of which she spoke. In the center of the circle, there is a large island that's planted with very old growth cedar, and there are some forsythia bushes also there. And it's really, because of the structure of those trees, which have a lot of low branches, it's really easy for kids to climb. And that was the center of all the kids' life on that circle growing up. But because it is planted, it also presents a danger, because if you're on the side of the street where 25 Reeves Circle is, which is opposite, there's a road that leads up to the circle, then directly in front of you is the planted area, and then behind that is number 25. That's the house where I grew up. And if you're at 25 or the houses immediately adjoining number 25, you can't see what's coming up that street. So if there are kids playing on that street, they can't see an approaching car. So when you have that gas station and you're adding that much traffic to it, you're going to increase the traffic on Reeves Circle. I don't know that the applicant's traffic engineer studied traffic patterns on Reeves Circle. I don't know, so I can't comment on that. But I'd like the board to be aware of that. Another point is that, and you probably guessed this from my questioning of Mr. Pesolano, there was a nursery on that site in the 1960s, and my dad, Harry Rosenthal, probably landscaped about 50% of the property at number 25 with trees and shrubs from that nursery. It was huge, and it actually extended down to where the medical arts building, one of the medical arts building is. And the medical arts building was the first to go. Oh, no, I'm sorry, I can't speak to which went up first, but when that nursery was sold, the medical arts building and then Bernie's Exxon went up on that site. Bernie Greco is the one that owned that gas station. And okay, that's my next point. And then finally, you know, since the last hearing, we've had the results of the election certified. Well, what's that got to do with Millburn? The incoming president-elect is very much, he's very pro-environmental, and he intends to reduce the number of gasoline-powered cars. And California is at the forefront of this. California has the largest automobile market in the United States, and their environmental laws largely drive what happens in the rest of the country. California is, I believe it's by 2050, is going to outlaw gas cars. Well, what's that got to do with Millburn? If you are allowing a multi-use gas station to go into that site, yeah, they might have business for a decade or so. But what's going to happen to that site as more and more electric vehicles take to the roads? And we don't need gas stations anymore. People are plugging in their cars at their garages and don't have to fill up. So I'm asking you to look at the big picture and where we are headed as a state and as a nation, because I think that in a number of years, in the not so distant future, certainly our kids aren't going to be my kids aren't going to be filling up at a gas station for much longer. So I know that may not be a test under the regulations that you folks are guided by, but as Millburnites who have a vested interest in not seeing future abandoned sites in this community, and who want to leave their children a beautiful place to live if they want to continue, I don't think that is the best and highest use for that particular site. Thank you so much.
Bill, can I ask Mrs. Rosenthal a question?
Sure.
So, Mrs. Rosenthal, you're in a unique position. I just want to zero in a little bit more on your comments and of your neighbor about the quality of life on the street, particularly for the children as it pertains to traffic. So you've lived there when there was a gas station, and now you've lived there for almost 10 years without a gas station. Can you just give us a little flavor based on your observations, traffic flow, things along those lines, specifically on that street?
Well, I know that when I was a child, it was rare to see a car come up that street. And, you know, it was almost like the kids would, you know how kids are, they kind of get excited because it's like, oh, a car. And as the years have progressed, there's a lot of people now that come and use Reeve Circle as a turnabout. You know, if they get lost, it's easy because it's a circle. They can go right up the street and follow it around and then come back out to Millburn Avenue. So yes, there is increased traffic. That is anecdotal. You know, I have to be honest. I haven't ever done a car count, but certainly there is increased traffic on that street.
Okay, thank you.
Thanks for your question.
Are there any other members of the
Can I
public?
ask a question?
Yes.
Ms. Rosenthal, I think maybe I must have got your address wrong, because I thought you said you lived on Main Street.
Yes, I do.
Okay. But you,
And
so
I
you,
did say that.
right.
But my
You don't live
mother,
on Main
my mom,
Circle now. I just want to make sure I have your address right. You
yes,
live,
that's correct. My mom still lives at 25 Reeve Circle, and
Okay.
I visit her all the time.
okay.
You know, it's about a mile away.
I just want to make sure I had your street address right.
Yes, you're correct, Ms. Fraser.
Are there any other members of the public who would like to weigh in on this case?
Yes, hold on one second. I'm gonna bring, hold on, I'm gonna bring over Marilee Raceback. And then I mistakenly brought Mr. Pissolano back over.
Ms. Riesbeck,
Yes,
you
hi,
need to be sworn first.
I'm aware.
If you would just raise your right hand, please. Do you swear or affirm the testimony you're about to give in tonight's hearing to be the truth, the whole truth, nothing but the truth?
I do.
Please state your name and address for the record.
Marilee Reesbeck, 91 Whittingham Terrace in Millburn.
Thank you.
Thank you. Okay, so I've been updating my statement on the fly based on some information that I just heard. I represent the South Mountain Civic Association, a 100-year-old neighborhood advocacy group for the neighborhood of South Mountain. Our neighborhood's eastern boundary is B'nai Israel, the parking lot across from the Vauxhall Road from the proposed gas station, and extends over to Taylor Park in downtown Millburn. We have followed the progress of New Jersey Energy's application since it was first presented to the zoning board. And we are concerned about several aspects of the New Jersey Energy application and their request for numerous variances. We're originally focusing on two of those, what we perceive to be the absence of an environmental impact statement, as well as the proposed sale of food and drink at the Chestnut Mart. The Rollway River winds through the South Mountain neighborhood, and while the river may look like a harmless stream, when it has flooded, the rollway has caused millions of dollars in property damage to communities along the banks. One location that has flooded during many storms in the past is that intersection of Vauxhall Road and Millburn Avenue. The gas station previously located there and the underground storage tanks on the property. New Jersey Energy indicated at a meeting in late 2019 that there would be a hearing before the New Jersey DEP early in the year. We would like to know what the determination was of that hearing. Again, my statement included a paragraph about objecting to the reuse of the underground storage tanks, so I'm relieved to hear that they're planning to replace those. In 2019, the Millburn Township Committee passed Ordinance 2528-19, which prohibits the sale of food and drink to the general public in the OR2 zone. Yet the discussion of a convenience store at the gas station has continued with specific details about the kind of food that it will be sold on the premises. The increase in both foot traffic and car traffic stopping in to buy food, drink, and other products at this location is one that concerns us. The increased risk of rodent infestation due to the on-site consumption of food poses an additional risk to our neighborhood. We oppose granting a variance for 2528-19. Again, we are asking the zoning board not to advance the application of New Jersey Energy and not to grant a waiver for the sale of food and drink in zone.
All right, you're
muted
muted.
yourself.
You're muted.
How did that happen?
I don't know.
Okay, again, we are asking the zoning board not to advance the application of New Jersey Energy, not to grant a waiver for the sale of food and drink in zone OR2. There was no convenience store connected to the gas station before the explosion in 2009, and we object to establishing a store at this location now. Thank you.
Thank you.
Ms. Riesbeck, you indicated that you represent the South Mountain Reservation Association?
South Mountain Civic Association.
Civic Association.
I'm the vice president. Our president,
No, but you're not an attorney, right?
I am not an attorney.
Okay, so I just want to clarify, more for your benefit than anything, that you're not representing the association, because I want to make that clear. You're appearing on behalf of them as a member.
I see. Thank you. Yes.
So you're the vice president.
I'm the vice president.
Okay, thank you.
Are there any other members of the public out there
Yes,
who'd
three
like to
more.
be heard on this matter?
I'm bringing over, it's labeled as MJSC Consulting. I don't know who that is.
Hi, excuse me. My name is Sherry.
Wait. Can you turn on your video?
Give me 1 second. Sure I can. One second. I think we're good now,
Okay,
right?
yes, we can see you. If you would just
Okay.
raise your right hand.
Okay, thank you. Yes,
Do you swear from the testimony you're about to give in tonight's hearing to be the truth, the whole truth, nothing but the truth?
yes.
Your name and address for the record, spelling your name.
Sherry Bar Chokrier, that's
Just-
S as in Sam, Hokrieh.
And your first name is with an S? or
Sherry,
S?
yeah, that's with Sherry.
Could you spell your last name again?
Sure. S as in Sam, Hokrieh.
And your address and your relationship to MJS Consulting?
That's just, this is my business Zoom account.
Oh,
My
okay.
address is, yeah, that's all. My address is 12 Reeves Circle.
Thank you.
Thank you. I have lived here for 32 years, and I'd like to speak about the traffic for just a little bit, please. I've heard comments from other people, and there was an interesting question by one of your gentlemen, I don't recall the name, a couple of minutes ago about the change in the traffic. That's not what I was planning on commenting on, but I would like to at this opportunity. There's a tremendous amount of increase in the traffic, even without the gas station. I mean, I can remember a time before we were not allowed to make a right turn on red at that corner. So if I was coming down Vauxhall Road, making a right to come home, I used to be able to make a turn. Did you know, am I being clear on that? I used to be able to turn right on red, and you can't do that anymore. I understand that the applicant's traffic study was done in July of 2017, if I remember correctly. And I don't know what time of the day that was studied, but now, especially nearing the rush hour time, that traffic to come up to Millburn Avenue and make the right off of Vauxhall, that can back up all the way back to Five Guys, on that parking lot there on the Millburn Mall. And that's without having that gas station there. So over the years, the traffic has increased. And one of my concerns, and it actually happened to me today, coincidentally, there are 2 bus stops that are on Millburn Avenue right near this particular site for the gas station that's being discussed. And I don't know if anybody even remembers that, but it's the number 70 bus. It's 2 bus stops, one going each way on Millburn Avenue, right there. And coincidentally, this afternoon, I was coming home about 3 o'clock this afternoon, and there were 2 buses there at the same time, which doesn't usually happen. But there was one bus going one way on Millburn Avenue, the other bus going the other way. They were both stopped. They were picking up passengers. I have a little sports car. I was in the middle of them trying to make a left. Somebody was behind me. And I'm saying to myself, there's nothing, the gas station's not there right now. There's no tanker truck coming out. There are no people, cars trying to come out of that driveway. And if I remember correctly, that driveway right there that I'm referring to on Millburn Avenue is the designated exit. I think that's what was discussed. So people would be entering the site off of Vauxhall Road, but they would be exiting onto Millburn Avenue, if I remember correctly. So I just wanted to point out that I just see the quality of life changing so much with this kind of a business in today, when the traffic, the congestion has increased over the years so much. And it's a concern for all of us turning in and out of our street, which is a little quiet street primarily, but turning in and out of the street, it's a concern, and I would really just ask the board to consider that. And I thank you for your time.
Thank you. Anyone else, Eileen?
Yes, one moment. Alex, I don't even want to say the last name because I'll probably say it wrong. Alex Malava. And then let me just take.
Okay, sir, if you just raise your right hand. Do you swear from the testimony you're about to give in tonight's hearing to be the truth, the whole truth, nothing but the truth?
Yes.
Please state your name and address for the record.
My name is Alex Moba, and I live at 17 Reeves Circle.
Thank you.
Hello, everyone. I'd like to take my time tonight to briefly summarize the Reeve Circle residents' principal points of opposition to this application. Number one, this application seeks to intensify the use of a site in a sensitive location. This intensification would be in the form of not one, but now two non-permitted uses in the zone. Number two, the site is too tight for safe operation of these two intensive uses together. The prospect for conflicts between vehicles, pedestrians, bicycles, children, and any combination of the above is greatly heightened by the small size of this site. Furthermore, the too many to count approaches to entering and exiting this particular site, together with all of the driver distractions around it, make it a particularly unsuitable for two traffic-intensive land uses. Number three, the nature of the two proposed uses is to attract and serve people in a hurry. This addition to the mix of concerns is a serious aspect and will threaten the safety of users and passersby by attracting drivers in a rush to get somewhere else onto a site with insufficient capacity for such activity. This condition would be further exacerbated by the frustration of drivers attempting to access the site, having been delayed significantly by the long backups this intersection is known to frequently have, excuse me. Number four, it is clear that the Township Committee recognized the sensitivity of this stretch of Millburn Avenue, and it continues to not endorse retail uses or gas stations in this location. And by Township Committee there, it may be the zoning board as well. So I apologize if that's not quite correct. Number five, there's no need for a gas station with a convenience store in this part of Millburn, as ample opportunities for purchase of gasoline and convenience items exist nearby. Number six, the site is unsuitable for two principal uses, as evidenced by the need to jam the proposed convenience store building into the corner of the site in violation of two prominent front yard setbacks. Worse, it forces the rear of this building to be what faces the very prominent public realm of the intersection of Millburn Avenue and Vauxhall Road. Number seven, thus the site is too small in too sensitive a location, likely to pose safety hazards on a daily basis, and a total departure from Millburn's master plan and zoning ordinances by virtue of the extremely odd placement of a principal building. Number eight, this location is a prominent entry point to Millburn. We should all be concerned with the appearance and function of this highly visible location. Number nine, I and my neighbors urge the board to reject this application for all the reasons we have presented through our comments tonight and the testimony of our planner, Michael Pesolano. Thank you very much.
Thank you. Eileen, anyone else out there?
And right, where'd she go? And Rosenthal.
Hello.
Hello. Can you turn on your video, please?
I'm trying. Okay, there we go.
Okay, if you would just raise your right hand, please.
Yes,
Do you swear or affirm the testimony you're about to give in tonight's hearing to be the truth, the whole truth, nothing but the truth?
I do.
Your name and address for the record, please.
Ann Rosenthal, number 25, Reeve Circle.
Thank you.
As you learned earlier from Judith Rosenthal, that I've been on the circle over 55 years. And it's been a wonderful place to raise children. I've always felt very safe. There really was never any problems living on the circle. But one thing I had a question about. I know that we did a on the traffic and what was happening, yet most of the study centered in on the traffic that is morning and early evening, actually late afternoon, early evening, but nothing was done for the traffic on Millburn Avenue from about 8 o'clock on. So what I did was park the car at the end of night before last, and wanted to see how much traffic really is there across from what's going to be a gasoline station. And from about 7:30 to 8 o'clock, if I saw 5 cars, it was a lot. The traffic is diminished after the traffic hour. And it's it's truly a safe neighborhood to raise your children. And we're not talking only about Reeve Circle. We have Norwood Terrace behind us, Ridgewood Road, other streets that go into Ridgewood Road, all with young families. This is a neighborhood. And no businesses are open after about 7 o'clock at night. There are a couple of hairdressers. There are the medical buildings are closed. It's a spot where there is very little traffic, very little annoyance, but I'm afraid what we're doing is setting ourselves up with that gasoline station plus a business. I didn't think you could have 2 businesses in one location, in one building. But what are we doing to the community? I was so happy to be able to raise my 2 daughters on Reeve Circle and not worry about them being outdoors, learning how to ride bikes and do some roller skating. But I don't know, with the fact that we're going to have cars coming in till 11 at night, they're going to find their way through Reeve Circle, I can guarantee you that. And how safe is that? Everyone on this circle works. The gentlemen go out during the day and are coming home to a safe environment. How many of us can say that? I think we all can. Millburn's a wonderful place to raise a family. I was born in Millburn. I can tell you about Millburn. And I always felt very safe here. When my husband retired from the military, we said we're going back to Millburn. And I was so happy to be able to live here. Please give it some serious thought. I know that you love Millburn. I know you're concerned about Millburn, but listen to us. Putting that station there with the hours they're going to keep, you're going to get cars coming in there eventually, and who knows what they have in mind. It's a safe place to be, and I hope you really, really give it some honest thought. If this were your environment, would you want this kind of thing going on? Thanks for hearing me.
Thank you. Is there anyone else in the public who would like to be heard before the board debates this matter?
I see no other hands.
All right, board members, this is the time when we need as board members to express ourselves.
Mr. Chairman, before you do that, do you want to give Mr. Pestilano an opportunity to close?
Sure.
A closing statement? Not Mr. Pestilano, Mr. Matt. Sorry about that. And also, Mr. Chairman, after he does that, you probably want to close the public portion of the hearing.
Sure.
Matt?
Great, thank you so very much, everyone. As everyone is well aware, tonight is a culmination of just over 2.5 years of land use hearings regarding this subject application. The subject application being the reopening of a pre-existing gas station, but instead of a service station, it would be the convenience store. As we all have heard of multiple times, this subject site since 1930 has operated as an auto service station. And then in 1970 and again 1996, it was confirmed that in fact it is a pre-existing non-conforming gas station service station. And in that 96 resolution, we also got to see that the board found warranting and justifying an expansion of that use to include the canopy and signage on the canopy, along with related improvements. Continuing on the history of this site to bring me up to today, as we all know, in 2009, unfortunately, there was a fire on the site causing damages. That fire on the site causing those damages caused the site to be closed for a number of years. And throughout that time period in 2012 Exxon decided to divest itself of multiple properties. Some of those properties, including this one, which went to NJ Energy. Now, when NJ Energy embarked on its journey with the subject site, they could have decided just to restore the site as is and avoided some land use procedures, and as a matter of law, reinstated that pre-existing non-conforming gas station service station use. However, after doing their due diligence, they have found that the gas station with a convenience store use was better suited for the subject site, consistent with the Medici standards. And that singular use that they have alluding to has been recognized by the national industry nationwide, and has also been recognized by our court cases here in New Jersey in J. Samram versus the Planning Zoning Board of Toms River. I understand, and I have most certainly heard, as well as the applicant and our professionals, those comments and concerns from the public, and it has not fallen on deaf ears by any stretch of the imagination. We believe that those items of concern have most certainly concentrated on traffic and operation. However, we believe by those concessions we have made on record, and also testimony we've provided on record, will hopefully alleviate some of those concerns. Most specifically, the traffic. Our traffic engineer, Hal Simoff, has specifically stated on the record that his conclusions showed there's no substantial adverse traffic impact to the subject site. To further ensure the safety of the site and the pedestrians, both walking and vehicular, we have made sure that we will prohibit left-hand turns from Vauxhall Road. And as regarding enforcing those safety measures, we will most certainly authorize the enforcement of Title 39 enforcement rights for the subject site to the township so that we can ensure the safety of the subject site. The next item was operations. We had discussed that the hours of operation would marry what is permitted by the zone code, which is from 6 a.m. to 11 p.m. Those would be the hours of operation for the subject site. We would also make sure that our lighting operations marry those hours of operation as well, so that there would be no concern of excessive light spillage in the early morning or late at night. When it comes to operations on the site, as we also testified to over the past few years, is that we do control all deliveries, whether it's gasoline or the sale of goods. And we would make sure that if this board were to find favorable, whatever their recommendation was, or the township engineer's recommendation for when those deliveries would occur, we would make sure that we comply fully to those hours of delivery for those consumed goods, I should say. Another item of concern was environmental, and that's most certainly a concern given the subject location to the Rahway River. As we had stated, this subject site is under the review of an LSRP. That licensed site remediation professional will make sure that we are fully compliant with NJDEP and we meet and/or exceed all those requirements. Also, as stated at the last hearing, my client had advised me that there was no triggering event, but rather out of best practices, we have decided to remove all tanks and replace them with double wall fiberglass tanks instead, as a further measure to make sure that the site was sound. Last but not least, I just want to discuss real quick the fact that we have gone through this journey specifically because we firmly believe that it is better to work with the community than to reinstate an outdated service. We believe that the auto service station, unfortunately, is a thing of its past, whether it be because of the noise pollution or simply because of the fact that most people get their car serviced now by a manufacturer that they originally purchased from. So with that being said, we do firmly believe that the proposed convenience store and gas station service use, which is now recognized as a singular use, is better suited for the subject site than the pre-existing use. And we hope that this board finds favorably. Thank you so very much.
Thank you. I'm going to close the public portion of the meeting now and ask the board members. But before you begin, board members, let me just make a couple of comments. The first is that I received 2 phone calls within the last couple of weeks. The first was by an unnamed member of the board saying that this member had been approached by someone in the neighborhood who wanted to deliver some materials, written materials, to the member. The member told this person justifiably and correctly that the member could not accept any materials and that any materials had to be presented at a board meeting and marked into evidence. So the second phone call I got was from another board member who advised me that this board member had seen on television an segment about what we heard tonight, which was that there was some money that was being directed to the county of Essex for improvement of difficult intersections, and that in Millburn Township, this was the intersection that was selected. I immediately proceeded to call our attorney and asked our attorney whether there was any thing that should be done with respect to this application as a consequence of that article. And our attorney advised me correctly, in my opinion, that we as a board had to rely on the testimony that had been given before this board, and that we could not in any way take into account the matter that was heard, that was presented on television or on the internet, I should say, and that we had to proceed to decide this case on the merits without reference to that material that was on the internet. And I just wanted to put those two things on the record so that we would be clear that we were focusing on the testimony that came before this board and our own personal awareness of what goes on in this community and in that particular part of the community. Okay, now having said that, is there any board member who would like to begin the debate or discussion among the board members with respect to this application? And I want to make mention of the fact that I'm holding in my hand the summary of variances requested, and I'm going to ask our attorney a question when I finish here. There were three variances on this sheet of paper. The first variance was a C variance, which dealt with improvements within a riparian zone. And that was deemed to be by the applicant an existing nonconformity, and the C variance was to request this board to presumably extend that variance. The other two were D variances. One was multiple principal use on a single lot. And the third variance, which was also a D variance, was to permit a gas station with a convenience store use on the lot, which was not, either were permitted. So my question really is, Gail, is should we even be talking about the riparian, or let me put it this way, if the B variances are rejected, does that automatically reject the C variance? And the second part of the question is, should we be debating all three of the variances now before any decision is made?
Well, first of all, you're only looking at the second sheet of variances on attachment E. You missed the first page of attachment E, which has another 7 variances listed on it.
Oh, thank you. I didn't even I didn't even open to that. You are absolutely correct.
If you recall, you have the front yard setback variance, you have a lot coverage variance. You have a pole mounted ground graphic area, sign area, the canopy structure, the canopy signs, the maximum wall graphic height, and the surface colors for the signs. So,
All of those are C variances.
right, they're all C variances. As for the riparian zone, I think that is an issue. They will need a permit from the NJDEP for riparian buffer. I believe that's going to be required. They're going to need DEP approval, I think, for the canopy and the building in the flood, because it's in the flood hazard area. So I think the riparian issue is a pre-existing non-conforming use, and any issues associated with that are going to be issues that are going to have to be addressed by the DEP when they issue their permit, riparian buffer permit. So I don't think, while it may be a pre-existing non-conforming use requiring variance relief, I'm not sure how much debate there should be on that particular topic. You know, it's a 50-foot riparian buffer.
Board members, anyone want to start off?
Well, Joe, I just want to understand the point you were making. Were you saying that if we don't pass on the Ds, we don't have to vote on the Cs? Was that the point you were making?
That was the question I was putting to get to Gail Fraser.
Right.
I think you should start with the Ds, because if you're not going to grant D variance relief, that's a good starting point, number one. My suspicion is that even if you're not granting the D variance relief, I'm not sure what the applicant's proposal is in terms of reopening the gas station, whether they still would plan on putting the island where it's proposed, whether they would still require the new canopy where it's proposed, or what. So I'm not really sure what happens with all of the remaining C variances. That might be a discussion we would have to have with Mr. Posada.
Okay.
Okay, on the D variances, board members, anyone have an opinion they would like to express?
Can we take them one at a time?
Sure. The two that I see are multiple principal uses on a single lot and a gas station with a convenience store use, which is not permitted. Those are the two D variances. Anyone?
Well, let's take the first one you mentioned regarding the two separate businesses on the lot. I mean, clearly that is the case. And I think that sort of trying to figure out the criteria of how that can exist as opposed to it not. I'm not sold that this property is capable of handling two separate businesses, even if it was to be granted. It's a small lot. It's a very high intense use. And I'm not sure this is the right property that if you were going to grant the ability to run two separate businesses on the lot, this would be the example of where to do it. So from my perspective, I would not support that application for variance relief.
So I agree with Craig. I think that there's been ample evidence presented, by the neighbors, by their professional, and just on my own observations, frequently that intersection, that it is an overbuild. on that lot of these two businesses. And, as intended, it's intended to be a high intensity area in already a pretty high intensity area at its highest point in rush hour. And yeah, I don't see how how that area could support those two businesses safely.
Joy,
I would agree with both Craig and
lean
Steve.
in closer, please.
I would agree with both what was said by Steve and Craig. I haven't, and in the testimony that was given, I listened and I hear many reasons why those uses are not well suited for the site. I haven't been able to find any reason for why they are well suited, either one really. And the argument was made that the pre-existing was a service station and a gas station, and that they could have just gone ahead and just not even come before the board. But then that doesn't make any sense to me, because those are not uses that work anymore. I'm having trouble with, between the size of the site, the geometry of the site, the proximity to residential, the high intensity of that intersection. I really don't see that this particular site is well suited for two uses or either of the proposed uses.
Mary?
I have some difficulty with the rear-facing convenience store, because that would be an isolated application in this community that is nowhere evidenced anywhere else. And I think it's particularly difficult to conceive of it being there on that intersection.
We do have it, and this board did grant it on the Walgreens on Morris Turnpike and Millburn Avenue. Very, very different setup, but that is one example I can think of where we have.
Well, but I think I don't think that applies to the thinking that I was trying to convey.
Right.
The rear of the convenience store is facing the street and facing the neighborhood and all the other buildings on the streetscape. It's nothing that has ever been debated or considered by in the master planning process. And I don't think that it's appropriate here.
Well, let me chime in, if I might. I am definitely opposed to this application in all regards. First of all, in all my years on this board, I don't think I have ever heard a witness, certainly not an expert witness, admit to the board that he or she had never set foot on the property. We heard that in this case by the gentleman who the first of the two gentlemen who came before the board to talk about the plantings on the property. He told us at least twice, maybe three times, that he was there only because the woman who had devised this landscaping plan had left his firm. And he didn't say it, but he might have gone ahead and said it. Anyway, he was drafted to come before this board to present her plan. It was horrendous testimony. I asked a question that has never been answered, either by him or by the other expert who came in his place on the next hearing. And my question was, given the nature of the potential flooding and historical flooding on this property, was the proposed landscaping, especially that under the building, which was built on pilings because of the flooding on the property, was it likely to survive? And that question was never answered. I think the answer is clearly, in my judgment at least, I'm not a landscape expert. It is not going to survive. It would not survive. There's a reason why the Township Committee zoning prohibits two principal uses on one lot. The principal reason for that prohibition is the tightness of most lots. And boy, if there's ever a situation, and I think others have already commented on this, where the lot is too small to accommodate two businesses, this is the lot. I have driven into gas stations for all of my life, ever since I got a permit. And I know that in many instances, people drive around to get to the other side of the pumps. They drive around cars that are being where the gas is being pumped into the car. And I will not vote for a situation where a youngster sitting, sitting in the back of a vehicle says to the mom or dad in the front seat, I want to run in to the convenience store for a minute to get a candy bar or to use the toilet or whatever, and opens the door to the car just in time for another car to circle around to try to pass the car that is being gassed, and at the same time, a car backing out of one of those parking spaces that are shown on the drawings that we were given, the head-in parking to the proposed store. It is in my judgment, this lot is entirely too small to safely accommodate that kind of movement within the lot, and I would be strongly opposed to it. So I don't ever get to the C variances. I think the answer is, in my judgment, if we turn down the D variances, or even one of them, like multiple principal uses on a single lot, which is a D variance, the others become irrelevant. Anyway, I didn't mean to get quite as exercised as I did, but as you can see, in all the years that I've been on this board, this is one of the cases that has affected me the most and affected me in a negative way. I think it's a terrible, terrible application. Put aside all the other things that we know about that lot. I've been in this town and driving in this town for the last 40 some odd years. And that is one of the worst corners in the community. To put two uses on that lot, one of them a convenience store, I'm not going to vote for it.
Mr. Chairman, I think I would urge the board to consider both of the D1 variances simultaneously. And I think the argument could be made that to a large extent, most of the variances, the C variances, could be considered subsumed within whatever decision you, if the board ends up voting to deny the D variances, the remaining C variances are subsumed within that denial because 4 of them relate to graphics associated with the canopy. And I'm not sure that the canopy would go in the location shown on the plans in a different configuration. And clearly the front yard setback is associated with the convenience store. So if the board is inclined to deny the variance to permit 2 principal uses on the site, gas station and convenience store, arguably that also is subsumed within the D variance decision.
Thank you, Gail. Is there a motion with respect to the 2 D variances? Yes.
Motion to deny.
Second.
Jody has something.
Sorry.
To say. Let her say it first.
Yeah, Joe, I just wanted to make a comment that the 2D variances are also interrelated. Multiple
Yes.
uses and then having convenience store. So I would not be supportive of both the D variances.
And Craig, were you the one that made that motion?
Yes, I made a motion to deny the applications, the 2D variances, if we start with that.
And I would second it.
Jody Sharma seconds it.
And
Motion to deny both of the D variances.
with the, with the C with the C variances subsumed within.
Subsumed in them.
No.
Correct.
Mary McNabb,
Yes.
Craig Plattner,
Yes.
Jyoti Sharma,
Yes.
Joy Siegel,
Yes.
Steve Toger,
Yes.
Jessica Glatt,
Yes.
Joseph Steinberg.
Yes. All right, we have come to the end of our formal agenda. I have a few words I would like to say concerning the fact that this is Gail Fraser's last actual meeting as the attorney for this board. She became the attorney for the board 2 years before I joined the board. That is to say 18 years ago. And I have to tell you that in my judgment as an attorney, she has done an absolutely spectacularly wonderful job. Now, I asked Mary McNabb as to whether there was anybody left on this board, anyone on the serving on the board who was on the board during the most difficult and arguably maybe New Jersey's most difficult hearing ever. And Eileen Davitt is going like this. Yes. Okay. Well, we had a matter where we had 17 hearings over 22 months. And Gail Fraser was responsible for drafting the resolution for that case, which came, by the way, the last two hearings were held in the auditorium of the high school.
Right.
That's how much interest there was in this community over
With
that.
with police presence, I might add.
Presence. And there was an absolutely dramatic incident that occurred.
Oh my gosh.
Concerning a board member who will not be named. At the second to last hearing, I left that hearing room and my only thought was, I've got to talk to Gail Fraser about this. I called Gail the next morning and I said, what are we going to do about what happened up on the stage of the high school auditorium? She said, let me make a phone call. She called me back 15 minutes or 20 minutes later and said, the affected individual has retained an attorney to advise that individual as to what that person should do. By the way, the person recused on the case. But Gail then cranked out a resolution in that case, a resolution of denial, fully aware that there would be litigation that would follow that resolution. Gail, that resolution was how many pages?
I think it was about 122 or 129 pages long.
I know it was.
It was pretty long. It was pretty long.
It was pretty long. It was more than 120 pages long.
Yeah.
And Eileen read every word of it, right, Eileen? Say yes, Eileen.
Yes.
Okay. All right. Now.
Luckily, that litigation is completely at an end. So that's.
I want to tell you that as someone who has taught this stuff on a law school level, you can read the Cox volume, which is the Bible that we all go by in this profession. in this area of law. And it will tell you that there's a problem with attorneys for boards. Many of them seek to take over the board position and run the entire evening, run the entire meetings. We have been extremely fortunate. I hope all of you are as aware as I am of Gail Fraser's proclivity for interjecting herself only when it's absolutely necessary. I'll give you an example of something that happened very recently before this board. You were all members of the board at the time. There was an application that to improve a home, two people who lived in the adjacent house appeared before this board and objected to the proposal. The applicants, husband and wife, were represented by a very experienced architect who said to them in full hearing of the board, I think we should apply, apply for an adjournment. The applicant, the male, said, no, I want to go forward. And Gail Fraser said, let me explain to you the law of res judicata. She explained it very clearly to him, and he responded, I didn't know that. I think we should ask for, for an adjournment. And they got the adjournment, and they came back at the next, I guess it was the very next hearing or the one after that. And the most objectionable aspects of their proposal had been deleted. The neighbors were nowhere to be seen. I don't think they even came to the next meeting. Why am I raising that issue before you tonight? Because that's a mark of an excellent attorney. Someone who sees when it is necessary for an attorney to interject him or herself into the hearing to make things smooth and to keep things moving in the right direction. I, for one, have been blessed for all the years that I've been chair of this board by having Gail Fraser at my right hand all the time. We're going to miss her. And Gail, as far as I'm concerned, you've done a spectacularly good job.
Thank you, Joe, for the comments, the very kind words, and I appreciate it. I'll miss all of you. I know you're going to have an interesting year. You're going to start off still in the Zoom mode, and you'll have a new attorney, so that'll be interesting because you won't get to interact with him in person, I'm sure, for quite a while. But you're all familiar with him, and he's a great lawyer. And I know you're all going to get along very, very well. And it's been a real pleasure and an honor to represent Millburn as long as I have. It's a fine town, and it's really nice to work with a board who is so concerned about ensuring that the municipality grows, but does so in a way that keeps the municipality the kind of neighborhood you all want to live in. So I commend all of you because I know it's a very time-consuming job, and you all put in a lot of hours visiting properties and giving a lot of thought to these applications. And some of you get stuck reading my resolutions, and I've always appreciated your comments. But I'm really looking forward to retirement, and I only have 2 more resolutions to do.
That's right, 2 more.
And
Okay,
I'm so glad that this is our last meeting in Millburn. My other municipality, they're wringing every inch of work out of me as they can. We have a meeting, a third meeting of the month scheduled for December 30th, and my last day is December 31. So we're going right to the wire in Morris Plains.
well, happy holidays and Godspeed.
Yeah.
Happy holidays.
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 Happy
Likewise.
holidays.
Okay.
Don't be a stranger.
No,
Is
I
there
hope
a
not
mo-
to be.
Is there a motion to adjourn?
Move to adjourn.
Is there a second?
Second.
All in favor?
Aye.
Good night, everyone.
Good night.
Bye,
night.
Gail. Bye-bye.
Bye.
Bye,
Take
Gail.
care, Gail.